But as it currently stands, there is no inherent cause of action based on the Constitution that would allow parents and teachers and victims to sue the police for inaction at Uvalde.
There's a certain legal schmiegel out there. I think you know who I'm talking about. The person who calls himself the Big Bird, unironically. This motherfucker went out here and said there's no way to collect against these guys.
Scalia wrote that under the Colorado law, police have discretion to decide whether to enforce an order, and if so, how they would do so. The court ultimately concluded that unless a legislature specifically said, we're creating this right, and if we breach it, the private citizen can then sue the government, then the citizen is out of luck. And as one court put it, quote, law enforcement officers often consider themselves responsible for protecting the public and deterring criminal activity. However, the legal doctrine that specifies the legal duty of law enforcement officers holds that they have a duty to the public, but not to individual citizens.
Not only is he a pussy, he's fucking wrong, okay? California cuck status. As a lawyer, you try to come up with arguments to make these motherfuckers pay. This is from the Texas statutes. So it's very hard under Texas law to claim for police fuck-ups. But it is possible if there's the action of an employee while responding to an emergency call, reacting to an emergency situation, if the action is in compliance with the laws, or if the action is not taken with conscious indifference or reckless disregard for the safety of others. So what this says is that these are situations where you can or can't make a claim. That says if you have conscious indifference or reckless disregard to the safety of others, you can pursue a claim in Texas. And I think this does rise to a reckless disregard for safety because they should have known and they failed to follow many of their different procedures. Now, does that mean that 100% liability is on the police? No, it can be portioned out to the school, to the police, to all those responsible. And Sam, I'm going to get to this argument here that SCOTUS says cops have no obligation. So here's the thing. People say, oh, but Andrew, all these cases say cops have no obligation to help you.
Now, that being said, the DeShaney decision recognized two possible exceptions to the general rule that the state has no duty to protect people from harm. The first is what's called the special relationship exception. As is usually summarized, quote, when the state takes a person into its custody and holds him there against his will, the Constitution imposes upon it a corresponding duty to assume some responsibility for his safety and well-being. And it's easy to see how the Fifth Circuit, which covers Texas, would probably make the same call in the hypothetical Uvalde case. Most courts reject the theory that people waiting to be rescued are in police custody and control. And perhaps the most analogous Fifth Circuit case is Salas versus Carpenter, where a county clerk was taken hostage at the courthouse by her abusive boyfriend. And during the hostage negotiation, the sheriff ordered that the city SWAT and hostage negotiation teams leave the courthouse. He then replaced them with county personnel not trained for SWAT or hostage negotiations. The man killed the county clerk. And the Fifth Circuit sided with the sheriff. The court said, quote, generally the absence of a special relationship defeats any due process claim based on a failure to provide protective services. The victim was not held in state custody or otherwise prevented by the state from caring for herself. This was a failed rescue effort. The police were doing something. They were securing the parking lot and stopping parents from getting inside where they might get hurt. And just because the effort failed and failed badly, probably wouldn't change the Fifth Circuit's analysis. But under the DeShaney case, there is a second exception, and that is called the state-created danger exception. And under that theory, some courts have recognized that state officials have a duty to protect individuals from harm when their actions created or exacerbated a danger to that individual. But here it seems like this exception wouldn't apply. The police didn't help, at least not in the way that most people wanted them to help, but at the same time, they also did not create the situation itself. In late 2020, the 11th Circuit Court of Appeals cited the Castle Rock and DeShaney cases and dismissed a lawsuit brought by the victims of the Parkland, Florida shooting at the Marjorie Stoneman Douglas High School. The 11th Circuit Court of Appeals, which is one step below the Supreme Court, found that a plaintiff could only allege a substantive due process claim in two situations. First, when the person was in the government's custody, and second, when government officials' conduct is arbitrary or shocks the conscience. The court held that in an active shooter situation, police have to make split-second decisions in the midst of chaos. In this situation, quote, an official's conduct will shock the conscience only when it stems from a, quote, purpose to cause harm. It is well established that school children are not in a custodial relationship with the state. A custodial relationship exists only if the government places limitations upon individual's ability to act on his own behalf that are similar in kind to incarceration or other forms of involuntary confinement. Ordinarily, there are no custodial relationships in the public school system, even if officials are aware of potential dangers or have expressed an intent to provide aid on school grounds. And unfortunately, that is the current state of the law.
Look at this over here. This is one of the cases. This is the Winnebago one, right? The Winnebago case. There are many cases like this. This is just one example. Thank you. And Don, you brought it up right now as I pulled it up. Right? Parkland, the Broward cases, they tend to say there's no obligation for the police not acting. First of all, a lot of those come out of domestic violence situations, which are factually different. They don't come up with the police not following their own policy and procedures. That's more along the lines of a reckless disregard. If the police have already engaged in doing something, they should do something competently. So in this way, I would not look at it as a police inaction. I would take it as an action that they grossly fucked up on. It wasn't because the police didn't choose to respond. For example, in the case of the Winnebago case, it was because they didn't respond when they knew somebody was a domestic abuser. They didn't respond. They didn't arrest him, so he killed somebody. They're already responding. They're there. They just aren't following their policies, their procedures, and they're fucking up left and right. So this, I think, should be looked at through a different lens. But even so, let me give you this. Let me give you the real way. This is the real reason that we should hold them accountable. It's because we can and do change the law. The law has and the law must continue to change. And particularly in the United States, we have a problem with these gun-free zones. If you think illegal guns don't get in, look at the countries that ban guns. You just had a person in Japan assassinating with a homemade gun the former PM. If you think you're not going to get a gun in to America, you are smoking crack.
Are you smoking crack?
If they can't stop somebody at the border, if they can't stop human smugglers, you think they're going to stop somebody smuggling in a gun? Get fucking real. Gun-free zones are bullshit. We got to pull out back a little bit because I think people are focused too narrowly on this, especially with the case law, because some of that case law needs to change. Reckless disregard, I think, would be an easy standard for a juror to find. And to not let it go there is kind of pushing us under the table. Here's the second way they could collect. And this is a real way they could collect. And I haven't heard any other lawyer talk about it because guess what? Most of them haven't dealt with this. But you know what? I have. Every state has the ability to authorize what are called special acts of legislation. I talked about on my channel the special act of legislation for Disney in Florida that allowed them to create their own city that can build nuclear power plants, that can do whatever the fuck they want, and is immune from taxes. That's a special act of legislation, something that they bring up and they do for a special scenario. You can also do that for liability. You can say, in this case, we are specifically authorizing claims. It's because this is something that needs justice. And that's something that Texas can do.
And it can be solved with legislation. But as it currently stands, there is no inherent cause of action based on the Constitution that would allow parents and teachers and victims to sue the police for inaction at Uvalde.